Man is born free, but everywhere he is in chains. A very warm evening, respected dignitaries and all other participants. It's a matter of honor to welcome all those who have gathered here to take part in today's invited lecture on HLA Hart's concept of law and morality, organized by Center for Advanced Legal Studies and Research, CALSER, in association with Kerala Law Academy Trivandrum, IQAC, KLA. Kerala Law Academy Law College sets its foundation into the legal arena in the year 1966 by the notable dignitary, the Dr. late Narayanan N. Nair Sir, through its various programs and events of international and national significance, has paved a way for excellence. Before moving further, let us spend a minute of silence to cherish the memory of our beloved late Dr. N. Narayanan Nair Sir. Thank you all. Today is third edition of Walk with a Scholar Lecture, Series 3. The topic for today is HLA Hart's concept of law and morality. Hart argues that law does not have to point beyond itself in order to justify its independence and autonomous existence. Natural law theorist says that law is based on morality. Hart supports the separation of law and morals. Now, with much pleasure, I take this opportunity to invite Shakti Prabha M. Sir, Assistant Professor, Kerala Law Academy, who is an active coordinator for all the events conducted by our college. With great pleasure, I invite you, Sir, to render the welcome address and provide a brief introduction about today's section. Sir, please.
Yes, thank you, Saraswati. A very warm greetings to each one of you. It is with great pleasure that I welcome you to the third edition of our esteemed Walk with a Scholar series, featuring a distinguished speaker, a young and vibrant academic known to our legal academic circles. We are very happy to have him with us today. Mr. Arjun Philip George, Assistant Professor of VIT School of Law, Chennai campus. As we gather virtually on this evening, we embark on a scholarly exploration of a topic that has left an indelible mark on the realms of jurisprudence, HLA Hart's concept of law and morality. Before we delve into the intellectual depths promised by our esteemed speaker, permit me to extend my deepest gratitude to all of you for gracing this occasion with your presence. Your commitment to the pursuit of legal excellence is a beacon to guide, which guides us all. Mr. Arjun Philip George is not only an accomplished academic, but also a fervent proponent of justice, equality, and human rights. His tireless efforts in both teaching and legal reform initiatives are a testament to his dedication to the betterment of society, to the noblest principles of law. Prior to VIT School of Law, he was an assistant professor of law at Christ, deemed to be University at Lavasa campus, where he acted in the role of custodian of exams, faculty editor in the editorial board, moot court committee member, etc. He has also worked as a research associate in the Committee for Scrutinizing Acts, Regulations, Rules relevant to the business community and citizens as part of the initiative of Ease of Doing Business appointed by Government of Kerala. He is also a recipient of the Justice V.R. Krishnayar Memorial Merit Award for securing the first rank in LLM. He is peer review board member of Student Law Journal, Dharmashastra National Law University, Jabalpur. The subject at hand, HLA Hart's concept of law and morality, stands at the crossroads of legal philosophy and moral reasoning. It beckons us to ponder over the intricate interplay between the law and morality, a discourse that has been at the heart of legal scholarship for decades. With Mr. George's erudition and passion, we anticipate an enlightening journey to this nuanced terrain. I also take this opportunity to thank and welcome Advocate Nagaraj Narayan Sir, Director Kerala Law Academy, Professor K. Anilkumar Sir, Director Administration, Students and Faculty Affairs, Professor K. Harindran Sir, Principal Kerala Law Academy, Professor G. Anilkumar Sir, Vice Principal of Kerala Law Academy, Professor Ajidana L. Ma'am, Senior Faculty KLA, and as a constant source of support and guidance which paved way for the conduct of this event. I would also like to invite Varun VS, Assistant Professor, KLL Academy, who will be also delivering the vote of thanks in the session. Ladies and gentlemen, as we embark on this intellectual voyage, let us not forget the significance of academic freedom in shaping the discourse of law and morality. It is through forums like this that we are able to contribute not only to the advancement of legal scholarship, but also the evolution of societal values. I encourage each one of you to actively engage with today's lecture, pose questions, and partake in thoughtful discussions. Let us harness the collective wisdom present here to enrich our understanding of HLA Hart's seminal ideas. Once again, I extend a warm welcome to Mr. Arjun Philip George, sir, our distinguished speaker, and to all of you, the esteemed participants. I have no doubt that today's lecture will be a valuable session and addition to a collective pursuit of legal excellence and academic freedom. Thank you, and let us commence this enlightening journey together. Thank you.
Thank you so much, sir. I take this opportunity to welcome you too into this event, sir. Today, we are blessed with the presence of our esteemed guest, Arjun Philip George, sir, Assistant Professor of Law at VIT School of Law, Chennai. He is a person who possesses the epitome of legal knowledge. Sir is the recipient of V.R. Krishnaiyer Memorial Merit Award for securing first rank in LLM. Sir has also attended 22 international conferences and 8 national conferences. We are honored to have such an exceptional personality to be the speaker for today. Now I invite Arjun Philip George, sir, to take lecture on the topic HLA Hart's concept of law and morality. So please.
Hope you can hear me well.
Yes, sir, you're audible.
Thank you for those kind words. I think I'll be one of the most junior persons among the professors who are present here. I was introduced to this session by my professor who delivered a session prior to me, Dr. Girish Kumar sir. He is my guide and he is my teacher, he is my mentor. And Professor K.C. Sandhi sir. I'm doing my research under Dr. K.C. Sandhi sir and Dr. Girish Kumar sir. So I'd like to give my thanks to both these personalities who gave me an opportunity or who gave me a space for today's lecture. And I'm so humbled by those words, and I don't deserve some of the compliments. I feel that I don't deserve some of the compliments which are given to me, like epitome of knowledge. I don't have that, and I don't claim to have that. I have one request. If possible, please switch on your cameras because I'm here to interact with the students and not with the system. If the students can switch on the cameras, it would be of great help for me to deliver the session in a better manner. So I request all the students who are present here to kindly switch on your cameras. And you can stop me at any point of time during this lecture. I'm here to ask you a few questions. I'm not here to give you answers. So I'm here to clarify a few of my doubts and make you confused. I'm not here to give you answers. So let's interact. The session is an interactive session. So please switch on your cameras. I would like to start my session with a question. How many of you are in favor of natural law school and how many of you are in favor of positivist school? Can you just write it down in comments if you want? One of you can switch on your mic and give your idea about these schools of thought. Any one of you? I've delivered sessions in Kerala Law Academy before. The students are very vibrant. Even after asking to switch on your cameras, most of you are reluctant to switch on your cameras. Please, this is an interactive session. I hope it to be an interactive session and not a one-sided lecture session wherein you all can sleep by switching off your camera. And I'm sitting here till 8:30 delivering a one-side lecture. That's not my intention. Please switch on your cameras. Please interact. please, it's a request, please. I'll call out names now. Selin. Please switch on your cameras, please. Priya. Srija. Yeah, thank you. Thank you. Thank you for the few who have switched on your cameras. I think those are the senior most among this crowd. Thank you, sirs, for switching on your cameras. So what do you think? Are you in favor of positive school or are you in favor of natural school? We are supporting natural school. Why are you supporting natural school? If you are in support of positive school, why are you in support of positive school? Any comments? No? Am I not audible from the actions of... Am I audible?
Yes, sir.
Yes, sir, you're audible.
It's sad that no one is responding, but I hope that you will start responding once the session progresses. Right. So I have shared my slides with the organizers. If the student who is in charge of it can present it in the screen.
Now it is
Audible.
Yeah,
Okay.
yeah. Because it was unmuted. It was
Okay.
muted.
So, sir, the question which I asked was that, are you in favor of positivist school or are you in favor of natural law school? I hope you know the basic philosophy.
Sure. Yeah.
Are you in favor of natural law school or are you in favor of positivist?
Yeah, from both we can take it.
No. You have to take one side.
One
Can't take
side.
both. My question is specific. Are you in favor of which side will you choose? Given an option, which side will you choose?
Natural law school.
Natural law school. Why? Because you are a believer. Is that a reason?
Yeah, one of the reason is that I am a believer.
Okay.
Yeah.
Okay. So in this presentation, I will be starting my presentation by explaining what is the basic philosophy of natural law school and what is the basic philosophy of positivist school. And then I will be moving on with the theory of H.L.A. Hart, because directly moving on to his theory won't make any sense without having an understanding of what natural law school is and what positivist school is. Is there anyone who is in support of positivist school here? Anyone who is in support of positivist school? At least to oppose George, sir. We need two sides. Lawyers should always be ready to represent different sides. Okay, let me take the side of positivists here, right? So first, as I said, we will be starting with an introduction about natural law school and about positivist school. What do you mean by natural law school? Who is one of the greatest? Can you name any one proponent of natural law school? Any one proponent of natural law school? Saint Thomas Aquinas is one of the greatest proponent of natural law school. He belonged to Catholic Church, and he believed in the concept that God have given us certain natural rights, and we human beings have a natural desire to pursue those goods, good, G-O-O-D, good, that is given to us by the God. So though he belonged to Catholic Church, he was not of the opinion that only Catholics will be saved by God, but he was of the opinion that all people were created by God, and God's intention was to give the best for his people, and hence the world was structured in such a nature so as to help people to achieve basic goods in their life. And he believed that God wanted the best for us. So by relating the school which Saint Thomas Aquinas belonged to, right? He was from a theological school of thought, right? And he propounded natural law. by saying that God created all human beings and God wanted his subjects to have the best for them. Yeah, can you please mute? Yeah, thank you. And can you please switch on the camera? Yeah. So where did I stop? God wanted best thing for his people, right? So you might feel that all Catholics might be automatically saved because Catholics are strong followers of God. What about people who are belonging to Hinduism, Buddhism, Jainism? So that's where St. Thomas Aquinas said that all these people are subjects of God, and God wanted his people to achieve the best. And how do you think God have structured us in such a way that we will pursue the best for us? Any idea? I'll give you one idea, right? All of us are concerned about our life. We'll make efforts to save our life. Whenever our life is in threat, we will make effort to save our life. Am I right? Am I right? If someone is coming,
Yes, sir.
the knife to you, right? At least you will run away from that person, right? You'll make effort to protect yourself from that person, right? Am I right?
Yes, sir.
So you have a basic instinct to protect your life. Now, where do you think this basic instinct is from? According to St. Thomas Aquinas, this basic instinct is created in you by God, so that he is thinking the best for you, so that you will save your life. That's why you have an instinct to save yourself from an attack, if any attack has been initiated against you by another person, right? The second basic good that is recognized by St. Thomas Aquinas is reproduction. All of us, after our inherent idea of saving ourselves and doing the best for us, we all, being in a society, we all contribute or are being part of the process of reproduction. In our society, we have an establishment called marriage, right? We enter into that establishment. There is husband, wife. After some time, the husband and wife will have children. Now, why do you think that reproduction is happening? It is because of natural attraction that one person, a man, is having towards a woman. Isn't it because of that natural attraction? And who do you think have created this natural attraction? God has created this natural attraction, right? According to St. Thomas Aquinas, because of which mankind is able to survive in this world. Okay, hope you're clear. If you have any doubt, please stop me, right? Whenever you are not able to understand a particular concept, please stop me then and there. What was the first basic good? Safia, can you answer? What was the first basic good which I pointed out? The first basic good was preservation of life. The second basic good that is recognized by St. Thomas Aquinas is reproduction. The third basic good which he recognizes is education. It is not just for human beings, even animals, right? These are applicable to all, including human beings and animals. Even animals value their lives. Animals enter into reproduction, the process of reproduction. And even animals go through a process of education, wherein the animal is being taught as to how to hunt, right? How to survive in the forest. They learn the basic lessons. Similarly, for us also, education is very important, which help us to differentiate between right and wrong. Now, these three factors are applicable to all beings, regardless of whether we are human beings or whether we are animals. Now, the fourth basic good that he addressed is applicable only with regard to human beings. He says that we have a natural tendency to seek God. Now, some of you here may be atheists, right? So you might not believe in the fourth good that is identified by Saint Thomas Aquinas. And for those people, I would like to quote Jean-Paul Sartre, who was also an atheist. Sartre addressed this particular point, which was raised by Saint Thomas Aquinas, as an inherent desire for a man to fill the vacuum in his mind. He did not say that it was a desire of man to see God, but he said that man always have a desire to fill a vacuum in his life. He was an atheist, right? So there is something which we always search for, right? Now, the fifth basic good that Saint Thomas Aquinas identify is that we are social animals. Are we social animals? Some of us might think that if we would have been alone in this planet, it would have been so nice. But according to my understanding, you won't be able to survive for long. Right? For human beings to survive, understand that we are social animals, and development of all our fellow beings is necessary for our development. This concept was first introduced to me by my professor, Dr. K.C. Sandhi sir. He said that you need not worry in this profession, you need not worry in the growth of another person. If one person is growing, you will also definitely grow. You have space to grow in this society. Because what if one of your friends grow, that friend can support you in your growth. That's how you should be seeing the world. Right. That's how Saint Thomas Aquinas identified the world, that we live in a society, right? Though we might prefer to be alone at some point of time, if loneliness is given as an option for our entire life, most of us won't choose it because of the reason that we are social animals. Since we are social animals, we have a tendency to avoid offense. Why do you want to avoid offense? Because you are part of a society. If you commit offenses, if you violate the right of another individual, you will be removed from this society. So you have an inherent desire to avoid offense. And the last one is you are inquisitive. I don't think the students who are present from Kerala Law Academy today for this particular session are really inquisitive. So I think Saint Thomas Aquinas is wrong in his finding that inquisitiveness is one of the basic good of human beings. If you want to prove Saint Thomas Aquinas' thought, please switch on your cameras and participate in the discussion. Inquisitiveness, what do you mean by inquisitiveness? Your desire to know, your desire to gather knowledge, right? So because of all this, please move on to the earliest slide. I'm still in the first slide. I don't have 50 slides. I only have 10 slides for my entire 1.5 hour session. So please move on to the earliest slide, whoever is controlling it. Yeah, thank you. So what are the 7 basic goods which I told just now? Can anyone of you say, repeat the same?
Preservation of life, reproduction, education, and have a natural tendency to seek God. Man is a social animal, and man is an inquisitor.
Yeah, and you missed one point. Man, since man is a social animal, he have an interest to avoid committing offense. Why? Because if he commit offense, he will be removed from the society. Okay.
Yeah.
Now, for each, so in natural law, you have a lot of negative duties that has been imposed upon you? What are the negative duties? Can you name one negative duty that has been imposed on by natural law? I'll quote one very controversial example. It is with regard to abortion. According to natural law school, abortion is not right. Why do you think abortion is not right?
Because we destroy a life. We destroy a life.
Okay, you're close to answer. Ashwati.
Because we don't have right to kill a human being.
Yeah. Okay. Anyone else?
Life is a blessing from God.
Okay. You're close again. Safia, do you have an answer? Vijay Lakshmi. Yes, Vijay Lakshmi.
Destroying one life.
As God gave us the, God blessed us with life. Only He has the right to take our life.
Okay. All of you are close to answer. But the reason is, what is the second basic good that is identified by Saint Thomas Aquinas?
Reproduction.
Yes.
Yes.
That is the reason why which natural law school is against abortion. They say that you are not supposed to abort because you're created in such a way that you have a natural tendency to procreate, and it is your God-given duty to procreate.
Yes. Duty to propagate.
Yes. So the prohibition here is you are not supposed to commit abortion. The basic good here is, can you identify the basic good? The second basic good. What was the second basic good?
Continue.
Reproduction.
Reproduction.
And the positive thing that is coming out from it is that you're procreating. You're helping this world. You are helping mankind to survive in this world. Did you get it? Can I ask you another question? You're not supposed to kill. Murder is a wrong. Why? Can you answer in this way? Can you identify the basic good?
We are destroying one life.
Yes, because the
Yeah,
first basic good says that man have a natural tendency to preserve life. Right.
Life. Yes.
So you also have a duty to promote the life of another individual. Man is a social animal. You are not supposed to commit offense.
Yes.
If you are committing offense, you will be removed from society.
Yes.
Right. So the basic good is life. The positive injunction is promotion of life. So in natural law school, there is always a prohibition which is based on a basic good, which result in a positive injunction. Is it clear? Any doubt?
Yes.
So are you all for natural law school?
Yes.
Okay. Now don't change your opinion. Okay. I'll come back to you again. I'll come back to Vijay Lakshmi ma'am again after some time. Okay. I hope that you will reflect the same opinion then.
Okay.
Right. So hope you understood what natural law school is. Now, what is positivist law school?
Positive law.
What is positivist law school? Positivist law school says that there is no space for morality.
Yes.
There is no space for morality. There is no one like God. Whatever law that we are having now is created by man. Is it right?
Right.
Then you are not supporting natural law school, ma'am.
No.
Is law created by man?
Yes.
Is the question clear?
Hmm.
Was Indian Constitution given to us by God?
No. That
No.
we created Indian Constitution.
Indian Constitution is not given to us by God, right? Indian Constitution is given to us by the Constitution makers, right? Constitutional Assembly.
Makers, yes.
So is it against the principle of natural law school? Okay, I'll come back to this discussion. So you got an idea about what natural law school is. We are still in positivist law school. Can you name any other philosopher apart from Hart in positivist law school?
Savigny, philosopher.
Savigny is from positivist law school.
Jeremy Bentham.
Bentham, Austin.
Bentham, okay. Austin. Who said Austin? Christy, are you the
Yes,
one
sir.
who said Austin?
Yes, sir.
Yeah, you're right. Austin was one of the greatest proponent of positivist law school. So have you heard of Austin's definition of law?
Yes, sir. The command of sovereign by political superior to political inferior.
Okay.
According to Austin, law is command of sovereign.
Command of sovereign is right. You miss one important part.
Backed by sanction.
Backed by sanction. Yes.
Yes.
Radhika, you said something. I missed you.
It's a philosophy of positive law.
Yes. No, I was asking about what positivist law school is, and the answer is given by Christy rightly. That positivist law school is a command of sovereign that is backed by sanction. Command of sovereign that is backed by sanction. Now, can I ask you a question? If I am having an ability to command, and if I have an ability to give you some punishment when you violate my command, can I be considered as a sovereign? And can my command be considered as a law? Did you get my question? Okay, I'll make it more simple. Consider that all of you are going to a bank, right? So a person is coming to that bank with a gun.
Yeah.
There is a famous series in Netflix, right? What is it called? I forgot. With that mask. What
Money
is it?
Heist.
Money Heist. Money Heist, right? Like, so a person is coming to that bank with a mask and a gun. The person is pointing the gun at you and asking you to put all the money that you are having and all the money that is there in the bank in the bag that he is having.
Yeah.
Can he be considered as a sovereign? Because there is command from his side asking you to put all the money that you're having in the bag. And if you don't put it, he will definitely shoot you.
Shoot me.
So there is sanction also if you don't obey it. So can he be considered as a sovereign?
No.
No.
Why?
Because he has no authority.
Let me tell you something very sad, right? All of us are lawyers. So you should be and we are discussing about
Violating law.
Yes,
jurisprudence is the philosophy of law, and you should be explaining it in such a manner that it is convincing to the person who is asking the question. You can also ask questions to me, right?
It is illegal.
Yeah, that is the most simple answer that you can give.
Yes.
It is illegal. But so if it is illegal, do you think that
There should be some law.
who said that it is illegal? Bini, right?
He threatened.
Okay. Someone said it is illegal. I think I couldn't identify who it is. Let me ask that person a question.
Bini.
Okay, Bini. The question is to Bini. Okay. You said that it is illegal. Consider that the state is shooting down people without a trial.
Oh,
Is that illegal, Bini?
yes, that is also illegal.
Then can you prosecute the state? Please give your answers after giving it a thought. Okay. Have you heard of a person called? Have you heard about a person called Grovasu?
Lowers.
Grovasu. Grovasu ചേട്ടനെ കുറിച്ച് കേട്ടിട്ടുണ്ടോ?
Vasu Chetana.
Grovasu.
Now he's being called to the court and he absconded. His boy.
Absconded?
No, he's being not absconded. He's being called to the court and he disagreed with the.
Maoist.
Okay, so there was an encounter killing in the state of Kerala. Now it's called as encounter killing, but we don't know what actually happened. As lawyers, we are not supposed to take sides until and unless we know that. This person was saying that the state has committed human right violation by breaking the law.
Yes.
But he was arrested. So when I asked the question, can state violate the law or can state kill people without a trial? If you are saying no, understand that for saying that a person was arrested. So be careful. So you're saying that it is illegal just because you are looking at it from the perspective of natural laws. Understand that in positivism, there is nothing like moral or immoral. Even state can commit wrong if there is a law that is backed by sanction. Command of sovereign that is backed by sanction. So coming back to our earlier question, let's keep the argument of illegality away. Can the person be considered as a sovereign? Can that person's command be considered as a law?
Command can be considered as a law.
Can it be considered as a law?
Yes.
It's a question. It
Yes.
can be considered as a law? No. Ma'am, please
Yes.
don't say that.
Yes.
It cannot be considered as law, right? It cannot be considered as law because of 5 major reasons. It cannot be considered as a law because of 5 major reasons. The first reason is that, so Austin defined what is law. If you try reading Austin, you will be finding it very difficult to understand Austin. Okay. So Hart explained Austin's concept of law. And in that, Hart is saying that a thing can be, a law is a law when it is a command of sovereign backed by sanction. Yes, but that command should be a general action applicable to people in general. In case of a person coming to bank, pointing gun at you, who is that command applicable to? People who are present at the bank, right?
Yes.
People who are present at the bank.
Yes.
The command is not applicable to other people who are standing outside the bank.
One and all.
It is not applicable to other people who are standing outside the bank. It is only applicable to people who are standing inside the bank.
Inside the bank.
Right? So that command is not general in nature. A command has to be general in nature. That is the first rule. When a law is being made in our country, consider that all of you are supposed to pay tax. If you are earning above a particular income, all of you are supposed to pay tax. If you don't pay tax, I will penalize you. That is what the state is saying. It is similar to a situation wherein a bank robber is pointing a gun at you and asking you to give your money. I'm not comparing the state with a bank robber, but consider the examples. In both cases, you are asked to give money. In one case, it is applicable only with regard to people who are present inside the bank. In the second case, it is applicable with regard to all citizens who are earning above a particular income. So the law is of general application. The command is of general application. Second, when a gunman is pointing a gun at you and asking you to give your money, that command is only applicable for that particular moment. Right? You might give money and the gunman might walk away. Does that person is having any authority on you after he walks away from you with your money?
Nothing.
Right?
He has taken the money and went.
No authority, right?
No
But
authority.
in an actual law, in an actual command, it will be persistent until it is withdrawn by the state. It will be persistent. Consider that you are paying taxes according to a particular rate until and until the government change it through a law, it will be applicable to you. So it is persistent. Third one is about efficiency. Efficiency. Consider that you are not giving money to that person who is pointing gun at you. Instead, you are using a stick which was there in your hand. Consider you had a stick, right? While you were going inside the bank, you were having a stick inside your hand. With that stick, you are attacking the person and you got the gun from that particular person.
Then
Can
it is
anything
well
be done?
Then it is well and good.
Then it is well and good, right? Ma'am, then you are not obliged by the command, by his command, right?
Yes, right.
But in case of state, you cannot attack state and say that you are not obliged by its command. The state will initiate action against you.
Yes.
State is efficient, right? Now, the last one is with regard to sovereignty. Can any of you define sovereignty? Can any one of you define sovereignty? Sovereignty. Command of sovereign backed by sanction. Christy, you were the one who gave the definition, right? Can you define sovereignty?
Yes, sir. So sovereignty is when a state is free to take any decision, free from any internal as well as any external factors.
Yes. So when you look into the slide, you can see internal and external points of view. So when I studied political science in my first year of law, my political science professor defined sovereignty as internal supremacy and external independence. Internal supremacy and external independence. Now, when a command has been given by the state is internally supreme, means that law will be applicable with regard to all subjects of that particular state. It will be externally independent, means it is not liable to take into consideration the advice given to it by other states. Consider that India is making a law. India need not comply with an advice which is given by Minister of Pakistan or Minister of Britain, because we are externally independent. Similar is not the case with a gunman who is pointing gun at you. He is not internally supreme. He is not a supreme authority. He is not independent. He is living in a society. He is obliged to comply with the laws of the society. Hence, the command of a gunman cannot be considered as a law, as it does not comply with the 5 major criteria. What are the 5 criteria?
Sovereignty.
The general nature, the persistence of the law, efficiency of the law, internal supremacy, and external independence. Is that clear? Any doubt? Asking doubt or no? Doubt. If you are worried to ask in English, you can speak in Malayalam. The point of language is to communicate. So you need not worry. Hope you're clear with this.
Yes.
Now let's move on to another concept called rule of recognition. Rule of recognition. What is rule of recognition? Any idea? Have you heard of Grand Norm?
Yes.
Who proposed Grand Norm?
Kelsen.
Kelsen.
Kelson's Grand Norm theory, right?
Yes.
So what is rule of recognition? Relate it. Try to relate it.
Pyramid. Pyramid structure. Structure is.
Rule of recognition says that if a law has to be valid, if a law or if an action has to be valid, consider that a police is arresting some police is arresting some person. Police is arresting that person under what authority?
Superior authority.
Penal authority, which is given to them under?
Under sovereignty.
No, under CRPC or under IPC, right?
IPC.
IPC is not replaced by the new code. So even now it is called as IPC. So let's call it as IPC. Okay. So police can arrest a person according to IPC, CRPC. Now, what gives validity to IPC and CRPC?
Constitution of India.
Oh, directly Constitution.
Constitution of India.
Let's not jump directly to Constitution. Before that, it's given validity by the legislature of the nation. Right? Legislature. Now, what is giving validity to the legislature of our nation?
Constitution.
Constitution. Now, what is giving validity to Constitution?
Constitution itself.
Constitution is the grand norm of our land.
Okay. Are you sure? Grand norm theory, you will trace it. Okay. You are close to the answer.
It says pure theory of law, and we, the people of India, we have how to explain.
Okay. Christy was saying that Constitution starts by saying that we, the people of India, do solemnly, right? It says that we are adopting this Constitution for ourselves. Can I ask you one question? Christy?
Yes, sir.
Were you there in the Constitutional Assembly?
No.
Then why are you saying that you were there? You were not there. Then why are you saying that we were there? I was not there.
Yes.
I was not there. I was not even born during that time. So how can you say that I adopted the Constitution? And I gave it to myself. Can you say that? I was not there during that.
We are forced to study, no?
Forced to study. Yeah? There is nothing like that. There is an explanation for everything. For this question, there is an
our representatives were there. And in a democracy, every person doesn't have a direct say. Our representatives take up voice of majority is there, and we have given it to ourselves.
I got your idea. Jaya, you were saying something.
I was also telling the representatives were there.
Okay. Was there actual election? Did all our forefathers participate in the election to Constitutional Assembly?
Yes.
No.
Huh?
Yes, yes.
No.
I don't think so. I don't think so.
Somebody will elect somebody.
I don't think so. All were not having equal opportunity to elect. So how will that argument stand? So understand that this was raised as a question before Supreme Court. I forgot the case name. But if you refer to V.N. Shukla, when you start reading preamble, the last paragraph ends with this. Yeah. We the people is a legal fiction. We the people is a legal fiction which cannot be questioned. Into a legal fiction. What is legal fiction? When you're talking about companies have a legal personality. But can you keep company behind jail, behind by the bars, if company commits any wrong? No. Because company is a creation of legal fiction. Similar is the Constitution, right? We the people is a legal fiction, which is the term that has been used by our forefathers while they were drafting the Constitution. But you cannot challenge the Constitution by saying that you were not there or our representatives were not there, right? So there lies the answer of what is rule of recognition. Rule of recognition says that when you trace back the validity of legislations, we will like the validity of the action of police depended on validity of IPC, CRPC, which was approved by legislature, which was according to constitution, right? And when you seek the validity of constitution, you might not be able to find anything. That is called as a rule of recognition, which cannot be traced back to any other rule. Is it clear?
Yes.
Is it clear?
Yes.
Yes?
Yes.
Yes, sir.
Yeah. Can you move to the next slide, please?
Concept legal positivism.
Sorry to interrupt, sir. Could you please explain the last point of that rule of legal recognition?
Rule of legal recognition says that to determine the validity of a particular action, you might need to trace it to a law. Right? To determine the validity of police action, you need to find whether the police is having authority under IPC, whether the police is having authority under CRPC, right? Now, if police is having authority under IPC or CRPC, what is the validity of IPC and CRPC? IPC and CRPC is valid because it is recognized by the legislature of our country. Now, what is giving validity to our legislature?
Constitution of India.
Constitution.
Now, what is giving validity to Constitution?
Supreme Court.
Supreme Court.
No. Even Supreme Court is under the Constitution. Even Supreme Court is established in accordance with the Constitution. You cannot say that Supreme Court is under the Supreme Court is above the Constitution. Right? So when you ask about the validity of the Constitution, some of you said that the Constitution makers adopted. Then I asked you a question, who gave authority for the constitutional makers? Then we had a confusion, right? Then I told you about the case which came before the court. And the court said that don't ask too many questions. This is the law, right? You obey this law. This is the basic law of our land, right? Right? So when we trace back the authority of a particular legislation, we are able to reach till the Constitution, right? So the Constitution is the rule of recognition or the basic law of recognition, because the validity of that law cannot be traced back to any other. But the validity of all other laws can be traced back to Constitution. Why is Right to Information Act valid? Because it is legislated by the legislature. The legislature was authorized to do so by the Constitution. Anything, take any action, you'll be able to trace it back to Constitution. That is why it is called as rule of recognition. It is not rule of law, it is rule of recognition. Rule of recognition. Okay? Is that clear, Christy?
Yes.
Yes, sir.
Yeah. Now let's move ahead. The concept of legal positivism. Hart's book is called The Concept of Law. The concept of legal positivism. The Hart was trying to define legal positivism by giving commentary on Austin, by giving an idea about what is the basis of legal positivism. Can you move to the next slide? Next slide, please. The concept of legal positivism is based on three major ideas. The first idea is separation thesis. The second idea is that of conceptual analysis. And the third idea is that of non-cognitivism. Non-cognitivism of morality. or ethics. Now let's try to understand what separation thesis is. Can one of you read what is written in the slide aloud? It's not visible for you. Can someone else read it? Radhika, can you please read it?
Yes, sir.
Yeah.
So law is a social phenomenon.
Hmm.
Legal systems are artifacts of human creation. They are something that human beings have created or posted into existence with their behavior and their thoughts and their words.
Okay. So this is what Hart defines law as. Hart says that law is a creation of human beings. Law is a creation of human beings, and it came into existence because of their thoughts and words, and not because of God. Okay, that is a basic understanding that Hart has had. Can you move to the next slide? Now, can you read what is given here, Radhika, again, please?
The contention that there is no necessary connection between law and morals, or law as it is and law as it ought to be.
Yes. What does it mean? Can you explain? Can any of you explain?
The law and morals have no connection, I think.
Yeah. But can you explain it? Why?
In all the cases, we can't show the morality for every cases. There need to be a certain law, and law need to be rigid in some cases.
Okay. I think you are very smart. But when I first read it, I didn't understand anything. But you are able to understand. And let me try to explain it for others. Understand that law is a social fact. Law is a social fact. What do you mean by that? Why is CPC called as a law? Because we have CPC, right? That is passed by our legislature. But that is approved by our legislature. Why is Right to Information Act a law? Because it is passed by our legislature. It is a fact. Why is POSH Act? What is POSH Act? Protection of Women from Sexual Harassment at Workplaces Act. Why is it a law? Because it is passed by our legislature. So law is a social fact. Whether law serves true justice, can you define justice?
Needy.
Adu Malayalam. Can you define justice? What I asked for is the definition. I couldn't find any convincing definition as such, but I will quote Dr. K.C. Sannison. I think all of you know him. He's my professor. When I was in his LLM class, he defined justice as to provide what is due to one. D-U-E. What is due to one? What do you mean by due? Due in the Malayalam. What is due? Something that is pending, right?
Pending.
Right. Something that is deserved by someone, but it is not given to that particular person. It is pending against that particular person. So when you're saying that a person has committed a crime against an individual, the individual is waiting for justice, which means that that individual is waiting to be restored in a status as before the crime was committed against him. Did you understand? Consider that you are walking through a road. You were hit by a car, right? So you'll go to hospital, but you suffered huge expense. You could not work. So you'll file a case in the court. When the court orders the insurance company to pay insurance to you, third-party insurance to you because of that car accident, then justice to an extent has been served, because that insurance money will help you to restore your position that you were enjoying before the accident. But if it is not provided to you, justice is not served. Do you understand the definition of justice?
Yes.
So understand that law can be unjust. Law need not be always just. Law can be unjust. Can you give me an example of an unjust law? Unjust law. Can you give me an example of an unjust law?
Time bar debt.
Time bar debt. How is it an unjust law?
You cannot get back the money after 3 years.
But there is a reasoning for the same. The reasoning is that one cannot rest over his right. You need not think too much. There was a famous case in the year 2018. The case name is No.3 Johar versus Union of India. Do you know what that case was about?
Partially decriminalized Section 377 of IPC.
Section 377 was there in existence from the year IPC was enacted till the year 2018. The judge in that particular judgment, Justice Indu Malhotra, she wrote, history owe an apology towards the people who are belonging to LGBTQ community. Now, can you say that law is always just? A Supreme Court judge is apologizing for not striking down that particular law beforehand, which clearly says that that law was unjust. Right? Right?
Yes.
So law need not be just. Law is just a social fact. Now, morality, on the other hand, is a question as to what law should be, what law ought to be. That question is irrelevant in a modern state wherein law is always dependent upon rule of recognition and on principles of whether it is passed by a sovereign backed with sanction. Right? So there is no connection between law and morality. There is no connection between law and justice. Is it clear? Is it clear?
Yes, sir.
Yeah.
Yes, sir.
Now, can you move on to the next slide? Conceptual analysis. Ritika, can you read that? What is written in the slide? Can you please
Yes,
read?
sir. The contention that the analysis of legal concept is worth pursuing to be distinguished from historical inquiries into the causes or origin of law, from sociological inquiries into relation of law and other social phenomena, and from the criticism and appraisal of law, whether in terms of morals, social aims, functions, or otherwise.
Can you explain this?
Contention that analysis. Can you
explain?
So it should be for the present situation, and it should not be for belongs to past or any future.
You're close to the answer. I'll give you a clue. Clue is there in that picture.
According to the inquiries.
Clue is there in the picture. What is there in the picture?
It's a bag.
It's a bag. Okay. Let's keep whatever there is in the slide aside. Is there anyone who is very much interested in cricket? Is there anyone who is interested in cricket? No one. Football.
Any other?
Is there anyone who is interested in cricket or football? There is no one. That's sad. Interested in any sport?
Basketball.
Basketball. Okay. What are the basic rules of basketball, Safia? How many players should be there? Okay. Safia is not responding. So let me, yeah, Safia.
I think it's 11. Sure.
Huh?
Not sure. I think it's 11.
Okay. You are also not sure. Okay. So you said that you are interested in basketball. That's why I asked you that.
I actually watched the game.
Okay. 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 So the point is, in basketball, there are some basic rules that there is a dimension for the court. There has to be 2 baskets in 2 sides. Right?
Yes, sir. I think there should be 12 players.
Okay. There should be a minimum number of players which has been prescribed. Right?
Yes, sir.
Does it say that the players should play by wearing particular attire? The basic rules of basketball might not prescribe for such rules. But the Basketball Association might come up with a rule saying that you should play basketball only by wearing shoe. Right?
Yes,
you should participate in basketball by wearing a particular attire. Right? So these rules are unnecessary rules. Even without these rules,
you can throw the ball.
Yeah, you can play. You can play basketball. You can play basketball.
Yes.
Even without wearing shoe, you can play basketball. When we were in school, we used to play, right? Football with a water bottle. We used to play football with a water bottle, and it was still football. The idea was to strike the ball into goal post. Right. Now, if you don't have ball, let it be a water bottle. What is the issue? So the basic law of a game is necessary. That is necessary to play that game. Cannot be taken away. But all other laws which are attached to it can be taken away. Even if when it is taken away, you will be able to play that game. Similar is the case with law. What is the basic thing that is necessary? Law should be in accordance with
legislature.
A legal authority. Right? In accordance with a legal authority, in accordance with the rule of recognition. That is the only necessary thing. You need not study history. You need not study, you need not conduct a study in the society to understand the needs of people. You can pass a law even without understanding the needs of people. Right? You can even pass a law without conducting a survey in the society. You might be studying ILCH, right? Indian Legal and Constitutional History. You might have studied. Have you studied something like that? Legal history? As part of your course? No, yes, maybe.
No, sir. No.
You haven't studied legal history.
Constitution.
It's in jurisprudence.
Yes.
Okay, in jurisprudence, okay, you have studied legal history, right, to an extent. Right, legal history, is it necessary? For law, is legal history necessary? You can pass a law even without legal history. If you have legal history, it's an added accessory. It's a baggage. It's an addition. Even without it, law is law, right? That is what conceptual analysis says. Hope it's clear. There are some essential basic law which has to be followed. Additional laws are not necessary. Similar is the case with law, right? In a game, there are certain basic rules. Additional laws, additional rules are not necessary for playing that particular game. Similar is the case with law. There are some basic features of law, like the law has to be passed by a sovereign. It has to be backed by sanction. There should be a rule of recognition. You need not study history for passing law. You need not conduct a social investigation for passing. That is what conceptual analysis says. Hope it's clear. Any doubt?
Yes, sir.
Next slide, please. Non-cognitivism. Can you read that, please?
Contention that analytic intelligence can be established.
One of you, aloud, please.
The contention that analytic cannot be established dependent on evidence of fact that can be rational argument, evidence, or proof.
Right. What does it mean? I have closed the door. It means that I have actually closed it. Right? It can be
open.
It can be considered as a fact. Right? I have closed it. Right? Isn't it a fact? I'm saying that I have closed the door.
Yes, it is a fact.
It's a fact. It can be true or false.
True.
True or false. Right? I may have closed the door. I may not have closed the door. I may have lied to you. Right? How can you assess it? You can check whether I have closed the door. Right? You can ask me to show the room around so that you can see that whether the door is closed or not. Right? You can check it. You can verify as to whether it is right or wrong. Charity is good. Is it true or false?
Charity is good.
You cannot say that to be it to be true or false because you can't verify it. How will you verify it?
Concept.
It is a subjective concept. Yes, you cannot verify it. I said that I have closed the door. I can prove it. I can prove it. When I am saying charity is good, and if you are saying that it can be, when I'm saying that charity is good, can it be proved to be true or false?
If you are giving charity, then we can prove. Not giving,
No. Even if I'm giving charity, I have given charity. That statement can be true or false.
That is true.
I have given charity. That can be true or false. Charity is good, whether it is true or false. You cannot determine it, right? Such is the situation with morals. You cannot determine the validity of morality. When there is a law in place, you can determine its validity by checking whether there is a rule of recognition. But in case of a morality, saying that homosexuality is wrong, how will you establish whether it is wrong? Did you get me? So morals are not having a position wherein it can be proved to be true or false. While law is having a position where it can be proved whether that law is in existence, whether that law is valid or not. How will you prove that whether a law is valid? We will check whether that law is in consonance with Part 3 of the Constitution. Part 3 of the Constitution says that all laws that is enacted by the state has to be in accordance with Part 3 of the Constitution. If it is not in accordance with Part 3 of the Constitution, then it is unconstitutional. But with regard to morality, how will you check whether it is right or not? Did you get the point? Because of these reasons, you cannot involve morality in law, because morality is not certain. Morality is an excess baggage. Morality is not necessary to determine the validity of law. That is the argument of Hart. Now, are you in favor of the legal positivism or natural laws?
Legal positives.
Okay. Can you move to the next slide? Now, Hart's legal positivism is criticized because of various reasons. The first reason is that it is always said that legal positivism lacked a moral base. Now, you can say that law is separate from morality. You need not compare law and morality because these concepts cannot be equated with each other. One is a fact, another depends on situations. One is subjective, right? So you can say all these, but when it comes to a situation, we always compare that situation with our morality. Let me give you one example. In the Nazi Germany, there were Polish soldiers and Jews who were persecuted in gas chambers. Many of them were defleshed, and their skeletons were used for medical trials. Human bodies were used for medical trials. They were injected with various viruses. The reaction in their body was assessed by the doctors. Many were sentenced to death through gas chambers, with the help of gas chambers. They were killed with the help of gas chambers. All these actions, understand that it was legally valid according to the laws which were prevailing in Germany during that time. But whether it is morally right,
No.
I'll give you another example. Have you heard of the case of ADM Jabalpur versus Shivkant Shukla? Have you heard?
Habeas corpus case.
Habeas corpus case. Do you know what the facts of those cases are?
Isn't
Do you know why that case is famous?
body has to be brought to the Supreme Court.
No, that is the meaning of habeas corpus.
Habeas
I'm
corpus.
talking about habeas corpus case. That case is called as habeas corpus case. Case name is ADM Jabalpur versus Shivkant Shukla. What is ADM Jabalpur versus Shivkant Shukla? Any idea? So during the time of emergency, there were a number of habeas corpus petitions which was filed before various high courts. The high court was doubtful as to whether to allow these petitions or not, because it was the time of emergency. So it was sent to Supreme Court. The Supreme Court said that you don't have fundamental rights, including right to life, during the time of emergency. It can be taken away. What does Article 21 say? Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. If there is a procedure established by law, your life can be taken away. Right? But there is one judge who gave a dissenting judgment, and his name is Justice Khanna. Justice Khanna gave the dissenting judgment in the case of ADM Jabalpur versus Shivkant Shukla, wherein he said that there are certain inalienable rights which cannot be taken away even during the time of emergency, like right to life, because right to life is not given to the citizen by the state. Hence, during the time of emergency, you cannot say that right to life is not there in existence. This judgment is known for the dissenting judgment of Justice Khanna, because it was a very progressive dissenting judgment, wherein he said, wherein the other judges were strictly interpreting the law according to legal positivism, while Justice Khanna, to an extent, tried to incorporate the principle of morality in his understanding of what is just. Okay. So that example also answers the second point, because in legal positivism, there is no scope for judges to interpret law to a great extent. I'll give you another example. How did Posh Act came into force? What is Posh Act? Protection of Women from Sexual Harassment at Workplaces Act. How did it came into force?
After Vishakha case judgment.
Vishakha.
The Supreme.
Vishakha was the state of Rajasthan. Now the Supreme Court in that particular case quoted a convention. You know the name of the convention? The name of the convention is CEDAW. Convention on Elimination of All Forms of Discrimination Against Women. CEDAW. The court said that the nation is in requirement of a legislation that protects women at their workplace. Now, can the court say, strictly speaking, according to the law, can the court say as to what the legislature have to legislate? The strict answer to the same is no. But when you allow a just interpretation of law, the Supreme Court can. Right? The third point is role of power. In legal positivism, understand that law is created as a result of power. Law is command of sovereign backed by sanction. Law is command of the sovereign backed by sanction. What if there is no command and then there is no sanction? So any regime, an oppressive regime, can also come up with a law that is having validity according to legal positivism, but may not be just. Have you heard of North Korea? You might have heard of the human rights violations which are happening in that particular country. It's because what they look is only whether there is a law which is there in force. They are not concerned about what is the kind of authority that is bringing in that particular law. Again, legal positivism to a great extent fails to take into account the social and historical context in which laws are being brought. Understand that law is having a connection with society. Is there a subject called law and social transformation for you? No. You might be studying.
Yes,
yeah, okay.
yes.
For
Yes,
LLM
sir.
students, there are, right? There is. So you are having that subject because of the reason that law is closely connected with society. Law cannot be interpreted or law cannot be understood in isolation. Law is having a history. Do you know what was the judgment which was given by the Supreme Court in A.K. Gopalan case? Are you aware of A.K. Gopalan case? A.K. Gopalan was the state of Madras. What was the case about? The case was about whether procedure established by law.
Article 21 violation. This is a violation of Article 21.
So the question was whether Article 21, whether the procedure established by law that is provided under Article 21 means due process of law. That was the question. The court said that procedure established by law means procedure established by law. It doesn't mean that the law have to be just, fair and reasonable. That was the judgment. But in Maneka Gandhi versus Union of India, the court said that there should not just be a law, but the law has to be just, fair and reasonable. And they evolved a principle called golden triangle. When there is a violation of Article 21, there can be subsequent violations of Article 14 and Article 19. Now, this is a change. This is our history. Right. This is how law evolved in our country. Article 21 evolved in our country, and it is having a great significance. We cannot move back on this particular evolution of law, which happened over the period of time. You cannot keep aside the dissenting judgment, which was given by Justice Khanna, which is of a lot of significance. So law has to be understood from a social context, which positivism fails to take into account. Now, legal obligation. There is a duty on the state. We were talking about the law that has been enacted by the state. Now, what about the duty on the state? Legal positivism fails to address the same. We are following the law because of a promise that we have entered into with each other. And according to that promise, the state has guaranteed us that they will step in whenever our right is violated. That is why we are obeying them. In a modern state, modern citizens, civilized state, civilized citizens are not obeying the law because they fear sanctions. That is a misunderstanding. We obey law because of the guarantee that if something happens to me, or if someone is trying to violate my right, the state will step in and defend my right. And when I lose that confidence, the state is having no value. So it is the responsibility of the state to protect that confidence of mine.
Yes.
Right. So legal positivism does not take into account the legal obligation, the reason for legal obligation. Okay. Hope you understood.
Yes.
Is that clear? Next slide, please. Though I criticize legal positivism in the last slide, understand that legal positivism, it's like a big ocean, right? I was able to speak to you for till 8:05 because of the reason that Hart wrote something on legal positivism. And it is of huge significance. People still work on it. People still do their research on it. People try to criticize the same. People try to base their arguments on the arguments which were brought in by Hart. So understand that it is of great significance. It is shaping our discussions. There are a lot of debates which were initiated by Hart's theory of law, like the Hart-Fuller debate, which you might have studied. If you haven't studied the same, please have a look into what Hart-Fuller debate is. I'll give you an idea about what Hart-Fuller debate is. Hart-Fuller debate was about the question as to whether the law has to be moral. The law has to be just. It was based on Nazi Germany's situation. So Fuller was of the opinion that the law has to be morally right, the morally just, while Hart was of the opinion that the law need not be based on morals, because what actually matters is whether there is a state and whether there is a law passed by the state. Please go through the debate and discussions which were there. There is no clear-cut answer for any of these. You can be a positivist, you can be a naturalist, natural law school propounder, right, or supporter. Doesn't matter, but what matters is that these philosophies are of huge significance and it is of huge value for us because of the kind of opportunity that it provides to a scholar to explore various doors of jurisprudence. What do you mean by jurisprudence? Jurisprudence is the philosophy of law. It's the study of law, right? Understand that philosophy is the ideal on which everything else has been based on. Recently, there was a controversial statement which was made by Udayanidhi Stalin, right? I'm not here to tell that statement, but there was a controversial statement. It became a controversy because some people think that the value of this particular nation is based on that particular philosophy. Similarly, our legal laws are based on legal philosophy or jurisprudence. Hence, it is very important to understand the same so that you'll have a better understanding of law and better understanding of justice. Okay, can you move on to the next slide? Thank you. You can contact me in this mail ID or in this number. I'm active in LinkedIn, Facebook, Instagram. You can contact me through any of these platforms or through my number or through my email ID and ask me questions. I hope that we can interact again. If there is any questions, I will take that now. The time which was given to me was till 8:15. I have concluded my session by 8:10. Right.
Sir, your opinion about that moral or what we should adopt, positive law or natural law?
Understand that from my understanding, you cannot, positivists give a better understanding about the process in which a law is being legislated, but we cannot completely stick on with the positivist law school or their idea of law, because of the reason that oftentimes justice will be compromised in positivist school. I might, to an extent, agree with natural law school by keeping aside the perspective of God, because of the reason that there might be people who might not believe in God. So they might feel that that concept is alien to them. It is very important to accommodate everyone into that particular thought. And even under natural law school, when you're saying that abortion is wrong, why do you think that abortion is wrong? Understand that one of our fellow citizen lost her life because a Christian country denied her the right to abort her child. So what if there is a situation wherein the life of mother and child is in question? Right. So the questions like that might come in, wherein you might be required to think outside the perspective of morality that has been given to you by your religion. Again, when you take section 377, you cannot justify it under the premise of natural law school strictly, because according to natural law school, reproduction is one of the important good that has been given to you by God. So the Navtej Singh Johar case would not have been passed. What about people who do not want to procreate? What about people who do not want to marry? Are they committing a sin? Should the state be allowed to prosecute them? So the answer to this is that we have a lot to learn from these theories. Blindly sticking on to one theory won't give us good results.
Thank you, sir.
Thank you.
Thank you so much, sir. It is not joy that makes us grateful. It is gratitude that makes us joyful. Now, I would like to invite Varun Dev sir, Assistant Professor, Kerala Law Academy, to deliver the vote of thanks for this event. Sir, please.
Thank you. So, ladies and gentlemen, good evening. Today, as we draw the curtains of the Walk with the Scholar, Lecture Series 3, featuring Assistant Professor Arjun Philip Jha, I have the distinct honor of delivering the vote of thanks on behalf of our prestigious institution, Kerala Law Academy Law College. First and foremost, I'd like to express our profound gratitude to Assistant Professor Arjun Philip Jha. His commitment to sharing his knowledge and insight with us, even in a virtual setting, has been truly exceptional. The depth and clarity with which he explored the topic of H.L.A. Hart's concept of law and morality left us all enriched and enlightened. Thank you. Assistant Professor Arjun Philip Jha, for your valuable contribution to our intellectual growth. I stand here with immense gratitude to extend heartfelt gratitude to our Director of Kerala Law Academy Law College, Advocate Nagaraj Narayan sir, and Professor K. Anilkumar sir, the esteemed Director of Administration, Students and Faculty Affairs at Kerala Law Academy Law College. Under the dynamic leadership of Professor K. Anilkumar sir, our college has been a beacon of knowledge, nurturing countless young minds and paving the way for their success in the legal world. We would like to express our sincere appreciation to our respected principal, Harindran K. sir, and senior faculties Anil Kumar Ji and Dr. Ajita Nair, whose vision, leadership, and unwavering commitment to excellence have shaped our institution into a center of academic brilliance. We extend our sincere appreciation to Shakti sir for delivering the welcome note for this event. His warm and gracious words have set the perfect tone for what promises to be a memorable occasion. We extend our sincere gratitude to our esteemed teachers for taking time out of their busy schedule to be part of this program. Your presence has made this event truly special and has left an indelible mark on all of us. I would also like to extend our sincere thanks to all our attendees, both students and faculty members. Your active participation, thoughtful questions, and engagement during the lecture have made this event a success. Your presence here signifies your dedication to the pursuit of knowledge and your support for academic excellence. Our gratitude goes out to the organizing committee and the technical team who work tirelessly behind the scenes to ensure the seamless execution of this virtual event. Your meticulous planning and attention to detail were evident in the smooth flow of the lecture. To our faculty members who encouraged and mandated the participation of our students, thank you for recognizing the importance of such event in the educational journey of our students. Your guidance is invaluable. A special thanks to all our students who are not only attended but actively engaged with the content. Your thirst for knowledge and your willingness to explore complex topics like this one are commendable. Finally, I would like to thank our online audience who joined us virtually from various parts of the world. Your presence, questions, and comments on social media platforms and a global dimension to our event, and we appreciate your interest in our academic pursuit. As we conclude this enlightening lecture series, let us carry the wisdom and insight guiding today forward in our academic journey. Let us continue to embrace learning and exploration as we strive for excellence. Once again, thank you all for your participation and support. Your presence has made the Walk with a Scholar Lecture Series 3 a memorable and intellectually enriching experience. Thank you and have a wonderful evening.
Thank you so much, sir. With that, we have come to the conclusion of this session. I would like to extend my gratitude towards Advocate Nagraj Narayanan sir, Director, Kerala Law Academy, Professor Anil Kumar sir, Director, Administration Students and Faculty Affairs, Professor Harindran K sir, Principal, Kerala Law Academy, and Professor G. Anil Kumar sir, Vice Principal, Kerala Law Academy, for their support and motivation throughout this event. I would also like to thank all faculties of Kerala Law Academy, LLM students, as well as LLB students for their presence. I would like to thank each one of you present here for your kind cooperation. And nothing would be possible without the wholehearted support and guidance of some strong-willed and determined people behind the curtain. You all together made this event a successful and informative one. Thank you, everyone. Have a great day ahead. This is Saraswati NR signing off. Thank you.
Thank you.
Thank you.
Thank you.